Title 4. Crimes Against Public Interest Chapter 1. Forgeries. Section 1. Forging the seal of the government of the Philippine Islands, the signature or stamp of the chief executive. Article 161. Counterfeiting the Great Seal of the government of the Philippine Islands, forging the signature or stamp of the chief executive. The penalty of reclusion temporal shall be imposed upon any person who shall forge the Great Seal of the government of the Philippine Islands or the signature or stamp of the chief executive. Article 162. Using forged signature or counterfeit seal or stamp. The penalty of prison shall be imposed upon any person who shall knowingly make use of the counterfeit seal or forged signature or stamp mentioned in the preceding article. Section 2. Counterfeiting coins. Article 163. Making and importing and uttering false coins. Any person who makes, imports, or utters false coins in connivance with counterfeiters or importers shall suffer 1. Prison in its minimum and medium periods and a fine not to exceed P10,000 pesos if the counterfeited coin be silver coin of the Philippines or coin of the Central Bank of the Philippines of 10 centavo denomination or above. 2. Prison regional in its minimum and medium periods and a fine of not to exceed P2,000 pesos if the counterfeited coins be any of the minor coinage of the Philippines or of the Central Bank of the Philippines below 10 centavo denomination. 3. Prison regional in its minimum period and a fine not to exceed P1,000 pesos if the counterfeited coin be currency of a foreign country. Article 164. Mutilation of coins. Importation and utterance of mutilated coins. The penalty of prison regional in its minimum period and a fine not to exceed P2,000 pesos shall be imposed upon any person who shall mutilate coins of the legal currency of the United States or of the Philippine Islands or import or utter mutilated current coins or in connivance with mutilators or importers. Article 165. Selling a false or mutilated coin without connivance. The person who knowingly, although without the connivance mentioned in the preceding articles, shall possess false or mutilated coin with intent to utter the same, or shall actually utter such coin, shall suffer a penalty lower by 1 degree than they prescribed in said articles. Section 3. Forging treasury or bank notes, obligations and securities. Importing and uttering false or forged notes, obligations and securities. Article 166. Forging treasury or bank notes on other documents payable to bearer. Importing and uttering such false or forged notes and documents. The forging or falsification of treasury or banknotes or certificates or other obligations and securities payable to bearer in the importation and uttering in connivance with forgers or importers of such false or forged obligations or notes shall be punished as follows. 1. By reclusion temporal in its minimum period and a fine not to exceed P10,000 pesos if the document which has been falsified, counterfeited, or altered is an obligations or security of the United States or of the Philippine Islands. The word obligation or security of the United States or of the Philippine Islands shall be held to mean all bonds, certificates of indebtedness, national bank notes, fractional notes, certificates of deposit, bills, checks, or drafts for money, drawn by or upon authorized officers of the United States or of the Philippine Islands, and other representatives of value, of whatever denomination, which have been or may be issued under any act of the Congress of the United States or of the Philippine Legislature. 2. By prison in its maximum period and a fine not to exceed P5,000 pesos if the falsified or altered document is a circulating note issued by any banking association duly authorized by law to issue the same. 3. By prison in its medium period and a fine not to exceed P5,000 pesos if the falsified or counterfeited document was issued by a foreign government. 4. By prison in its minimum period and a fine not to exceed P2,000 pesos when the forged or altered document is a circulating note or bill issued by a foreign bank duly authorized therefore. Article 167. Counterfeiting, importing and uttering instruments not payable to bearer. Any person who shall forge, import or utter, in connivance with the forgers or importers, any instrument payable to order or other document of credit not payable to bearer, shall suffer the penalties of prison regional in its medium and maximum periods and a fine not exceeding P6,000 pesos. Article 168. Illegal possession and use of false treasury or banknotes and other instruments of credit. Unless that be one of those coming under the provisions of any of the preceding articles, any person who shall knowingly use or have in his possession, with intent to use any of the false or falsified instruments referred to in this section, shall suffer the penalty next lower in degree than they prescribed in said articles. Article 169. How forgery is committed. Theft forgery referred to in this section may be committed by any of the following means. 1. By giving to a treasury or banknote or any instrument payable to bearer or order mentioned therein the appearance of a true genuine document. 2. By erasing, substituting, counterfeiting or altering by any means the figures, letters, words or signs contained therein. Section 4. Falsification of legislative, public, commercial, and private documents, and wireless, telegraph, and telephone message. Article 170. Falsification of legislative documents. The penalty of prison correctional in its maximum period and a fine not exceeding P6,000 pesos shall be imposed upon any person who, without proper authority therefore alters any bill, resolution, or ordinance enacted or approved or pending approval by either house of the legislature or any provincial board or municipal council. Article 171. Falsification by public officer, employer, notary or ecclesiastic minister. The penalty of prison mayor and a fine not to exceed P5,000 pesos shall be imposed upon any public officer, employee, or notary who, taking advantage of his official position, shall falsify a document by committing any of the following acts. 1. Counterfeiting or imitating any handwriting, signature or rubric. 2. Causing it to appear that persons have participated in any act or proceeding when they did not in fact so participate. 3. Attributing to persons who have participated in an act or proceeding statements other than those in fact made by them. 4. Making untruthful statements in a narration of facts. 5. Altering true dates. 6. Making any alteration or interpolation in a genuine document which changes its meaning. 7. Issuing in an authenticated form a document purporting to be a copy of an original document when no such original exists, or including in such a copy a statement contrary to, or different from, that of the genuine original. Or 8. Intercalating any instrument or note relative to the issuance thereof in a protocol, registry, or official book. The same penalty shall be imposed upon any ecclesiastical minister who shall commit any of the offenses enumerated in the preceding paragraphs of this article, with respect to any record or document of such character that its falsification may affect the civil status of persons. Article 172. Falsification by private individual and use of falsified documents. The penalty of prison correctional in its medium and maximum periods and a fine of not more than P5,000 pesos shall be imposed upon 1. Any private individual who shall commit any of the falsifications enumerated in the next preceding article in any public or official document or letter of exchange or any other kind of commercial document. And 2. Any person who, to the damage of a third party, or with the intent to cause such damage, shall in any private document commit any of the acts of falsification enumerated in the next preceding article. Any person who shall knowingly introduce an evidence in any judicial proceeding or to the damage of another or who, with the intent to cause such damage, shall use any of the false documents embraced in the next preceding article, or in any of the foregoing subdivisions of this article, shall be punished by the penalty next lower in degree. Article 173. Falsification of wireless, cable, telegraph and telephone messages, and use of said falsified messages. The penalty of prison correctional in its medium and maximum periods shall be imposed upon officer or employee of the government or of any private corporation or concern engaged in the service of sending or receiving wireless, cable or telephone message who utters a fictitious wireless, telegraph or telephone message of any system or falsifies the same. Any person who shall use such falsified dispatch to the prejudice of a third party or with the intent of cause such prejudice shall suffer the penalty next lower in degree. Section 5. Falsification of medical certificates, certificates of merit or services and the like. Article 174. False medical certificates, false certificates of merits or service, etc. The penalties of arresto mayor in its maximum period de prison correctional in its minimum period and a fine not to exceed P1,000 pesos shall be imposed upon 1. Any physician or surgeon who, in connection with the practice of his profession, shall issue a false certificate, and 2. Any public officer who shall issue a false certificate of merit of service, good conduct or similar circumstances. The penalty of arresto mayor shall be imposed upon any private person who shall falsify a certificate falling within the classes mentioned in the two preceding subdivisions. Article 175. Using false certificates. The penalty of arresto mayor shall be imposed upon anyone who shall knowingly use any of the false certificates mentioned in the next preceding article. Section 6. Manufacturing, importing and possession of instruments or implements intended for the commission of falsification. Article 176. Manufacturing and possession of instruments or implements for falsification. the penalty of prison correctional in its medium and maximum periods, and a fine not to exceed P10,000 pesos shall be imposed upon any person who shall make or introduce into the Philippine Islands any stamps, dies, marks, or other instruments or implements intended to be used in the commission of the offenses of counterfeiting or falsification mentioned in the preceding sections of this chapter. Any person who, with the intention of using them, shall have in his possession any of the instruments or implements mentioned in the preceding paragraphs, shall suffer the penalty next lower in degree than that provided therein. Chapter 2. Other falsities. Section 1. Usurpation of authority, rank, title, and improper use of names, uniforms and insignia. Article 177. Usurpation of authority or official functions. Any person who shall knowingly and falsely represent himself to be an officer, agent or representative of any department or agency of the Philippine government or of any foreign government, or who, under pretense of official position, shall perform any act pertaining to any person in authority or public officer of the Philippine government or any foreign government or any agency thereof, without being lawfully entitled to do so, shall suffer the penalty of prison correctional in its minimum and medium periods. Article 178. Using fictitious name and concealing true name. The penalty of arresto mayor and a fine not to exceed 500 pesos shall be imposed upon any person who shall publicly use a fictitious name for the purpose of concealing a crime, evading the execution of a judgment or causing damage. Any person who conceals his true name and other personal circumstances shall be punished by arresto mayor or a fine not to exceed 200 pesos. Article 179. Illegal use of uniforms or insignia. The penalty of arresto mayor shall be imposed upon any person who shall publicly and improperly make use of insignia, uniforms or dress pertaining to an office not held by such person or to a class of persons of which he is not a member. Section 2. False testimony. Article 180. False testimony against a defendant. Any person who shall give false testimony against the defendant in any criminal case shall suffer 1. The penalty of reclusion temporal, if the defendant in said case shall have been sentenced to death. 2. The penalty of prison mayor, if the defendant shall have been sentenced to reclusion temporal or reclusion perpetua. 3. The penalty of prison correctional, if the defendant shall have been sentenced to any other afflictive penalty. And 4. The penalty of arresto mayor, if the defendant shall have been sentenced to a correctional penalty or a fine, or shall have been acquitted. In cases provided in subdivisions 3 and 4 of this article, the offender shall further suffer a fine not to exceed 1,000 pesos. Article 181. False testimony favorable to the defendants. Any person who shall give false testimony in favor of the defendant in a criminal case shall suffer the penalties of arresto mayor in its maximum period, de prison correctional in its minimum period, a fine not to exceed 1,000 pesos, if the prosecution is for a felony punishable by an afflictive penalty, and the penalty of arresto mayor in any other case. Article 182. False testimony in civil cases. Any person found guilty of false testimony in a civil case shall suffer the penalty of prison correctional in its minimum period and a fine not to exceed 6,000 pesos, if the amount in controversy shall exceed 5,000 pesos, and the penalty of arresto mayor in its maximum period, de prison correctional in its minimum period, and a fine not to exceed 1,000 pesos, if the amount in controversy shall not exceed said amount or cannot be estimated. Article 183. False testimony in other cases and perjury and solemn affirmation. The penalty of arresto mayor in its maximum period, de prison correctional in its minimum period, shall be imposed upon any person who knowingly makes untruthful statements and, not being included in the provisions of the next preceding articles, shall testify under oath or make an affidavit upon any material matter before a competent person authorized to administer an oath in cases in which the law so requires. Any person who, in case of a solemn affirmation made in lieu of an oath, shall commit any of the falsehoods mentioned in this and the 3 preceding articles of this section, shall suffer the respective penalties provided therein. Article 184. Offering false testimony and evidence. Any person who shall knowingly offer in evidence a false witness or testimony in any judicial or official proceeding, shall be punished as guilty of false testimony and shall suffer the respective penalties provided in this section. Chapter 3. Frauds. Section 1. Machinations, monopolies and combinations. Article 185. Machinations in public auctions. Any person who shall solicit any gift or promise as a consideration for refraining from taking part in any public auction, and any person who shall attempt to cause bidders to stay away from an auction by threats, gifts, promises, or any other artifice, with intent to cause the reduction of the price of the thing auctioned, shall suffer the penalty of prison correctional in its minimum period and a fine ranging from 10 to 50% of the value of the thing auctioned. Article 186. Monopolies and combinations and restraint of trade. The penalty of prisión correccional in its minimum period, or a fine ranging from 200 to 6,000 pesos, or both, shall be imposed upon 1. Any person who shall enter into any contract or agreement, or shall take part in any conspiracy or combination in the form of a trust or otherwise, in restraint of trade or commerce, or to prevent by artificial means free competition in the market. 2. Any person who shall monopolize any merchandise or object of trade or commerce, or shall combine with any other person or persons to monopolize in merchandise or object in order to alter the price thereof by spreading false rumors or making use of any other article to restrain free competition in the market. 3. Any person who, being a manufacturer, producer, or processor of any merchandise or object of commerce or an importer of any merchandise or object of commerce from any foreign country, either as principal or agent, wholesaler or retailer, shall combine, conspire or agree in any manner with any person likewise engaged in the manufacture, production, processing, assembling or importation of such merchandise or object of commerce, or with any other persons not so similarly engaged for the purpose of making transactions prejudicial to lawful commerce, or of increasing the market price in any part of the Philippines, of any such merchandise or object of commerce manufactured, produced, processed, assembled and or imported into the Philippines, or of any article in the manufacture of which such manufactured, produced, or imported merchandise or object of commerce is used. If the offense mentioned in this article affects any food substance, motor fuel or lubricants, or other articles of prime necessity, the penalty shall be that of prison mayor in its maximum and medium periods, it being sufficient for the imposition thereof that the initial steps have been taken toward carrying out the purposes of the combination. Any property possessed under any contract, or by any combination mentioned in the preceding paragraphs, and being the subject thereof, shall be forfeited to the government of the Philippines. Whenever any of the offenses described above is committed by a corporation or association, the president and each one of its agents or representatives in the Philippines in case of a foreign corporation or association, who shall have knowingly permitted or failed to prevent the commission of such offense, shall be held liable as principals thereof. Section 2. Frauds in Commerce and Industry. Article 187. Importation and disposition of falsely marked articles or merchandise made of gold, silver, or other precious metals or their alloys. The penalty of prison correccional, or a fine ranging from 200 to 1,000 pesos, or both, shall be imposed on any person who shall knowingly import or sell or dispose of any article or merchandise made of gold, silver, or other precious metals, or their alloys, with stamps, brands, or marks which fail to indicate the actual fineness or quality of said metals or alloys. Any stamp, brand, label, or mark shall be deemed to fail to indicate the actual fineness of the article on which it is engraved, printed, stamped, labeled or attached, when the rest of the article shows that the quality or fineness thereof is less by more than 1/2 carat, if made of gold, and less by more than 4/1000th, if made of silver, than what is shown by said stamp, brand, label or mark. But in case of watch cases and flatware made of gold, the actual fineness of such gold shall not be less by more than 3/1000th than the fineness indicated by said stamp, brand, label, or mark. Article 188. Subsisting and altering trademark, trade names, or service marks. The penalty of prison correccional in its minimum period, or a fine ranging from 50 to 2,000 pesos, or both, shall be imposed upon 1. Any person who shall substitute the trade name or trademark of some other manufacturer or dealer, or a colorable imitation thereof, for the trademark of the real manufacturer or dealer upon any article of commerce and shall sell the same. 2. Any person who shall sell such articles of commerce, or offer the same for sale, knowing that the trade name or trademark has been fraudulently used in such goods as described in the preceding subdivision. 3. Any person who, in the sale or advertising of his services, shall use or substitute the service mark of some other person, or a colorable imitation of such mark. Or 4. Any person who, knowing the purpose for which the trade name, trademark, or service mark of a person is to be used, prints, lithographs, or in any way reproduces such trade name, trademark, or service mark, or a colorable imitation thereof, for another person, to enable that other person to fraudulently use such trade name, trademark, or service mark on his own goods, or in connection with the sale or advertising of his services. A trade name or trademark is herein used as a word or words, name, title, symbol, emblem, sign or device, or any combination thereof used as an advertisement, sign, label, poster, or otherwise, for the purpose of enabling the public to distinguish the business of the person who owns and uses said trade name or trademark. A service mark is herein used as a mark used in the sale or advertising of services to identify the services of one person and distinguish them from the services of others, and includes without limitation the marks, names, symbols, titles, designations, slogans, character names, and distinctive features of radio or other advertising. Article 189. Unfair competition, fraudulent registration of trademark, trade name or service mark, fraudulent designation of origin, and false description. The penalty provided in the next preceding article shall be imposed upon 1. Any person who, in unfair competition and for the purposes of deceiving or defrauding another of his legitimate trade or the public in general, shall sell his goods giving them the general appearance of goods of another manufacturer or dealer, either as to the goods themselves, or in the wrapping of the packages in which they are contained or the device or words thereon or in any other features of their appearance which would be likely to induce the public to believe that the goods offered are those of a manufacturer or dealer other than the actual manufacturer or dealer, or shall give other persons a chance or opportunity to do the same with a like purpose. 2. Any person who shall affix, apply, annex or use in connection with any goods or services or any container or containers for goods a false designation of origin or any false description or representation and shall sell such goods or services. 3. Any person who by means of false or fraudulent representation or declarations orally or in writing or by other fraudulent means shall procure from the Patent Office or from any other office which may hereafter be established by law for the purposes of registration of a trade name, trademark or service mark, or of himself as the owner of such trade name, trademark or service mark, or an entry respecting a trade name, trademark or service mark. Title 5. Crimes relative to opium and other prohibited drugs. Article 190. Possession, preparation and use of prohibited drugs and maintenance of opium dens. The penalty of arresto mayor in its medium period, de prisión correccional in its minimum period, and a fine ranging from 300 to 1,000 pesos shall be imposed upon 1. Anyone who unless lawfully authorized shall possess, prepare, administer, or otherwise use any prohibited drug. Prohibited drug, as used herein, includes opium, cocaine, alpha and beta-eucaine, Indian hemp, their derivatives, and all preparations made from them or any of them, and such other drugs, whether natural or synthetic, having physiological action as a narcotic drug. Opium embraces every kind, class, and character of opium, whether crude or prepared, the ashes on refuse of the same, narcotic preparations thereof or therefrom, morphine or any alkaloid of opium, preparation in which opium, morphine or any kind of opium, enter as an ingredient, and also opium leaves or wrappings of opium leaves, whether prepared or not for their use. Indian hemp, otherwise known as marijuana, cannabis, americana, hashish, bang, gaza, churros, and ganja embraces every kind, class and character of Indian hemp, whether dried or fresh, flowering or fruiting tops of the pistillate plant cannabis sativa, from which the resin has not been extracted, including all other geographic varieties whether used as reefers, resin, extract, tincture or in any other form whatsoever. By narcotic drug is meant a drug that produces a condition of insensibility and melancholy dullness of mind with delusions and may be habit-forming. 2. Anyone who shall maintain a dive or resort where any prohibited drug is used in any form, in violation of the law. Article 191. Keeper, watchman and visitor of opium den. The penalty of arresto mayor and a fine ranging from 100 to 300 pesos shall be imposed upon 1. Anyone who shall act as a keeper or watchman of a dive or resort where any prohibited drug is used in any manner contrary to law. And 2. Any person who, not being included in the provisions of the next preceding article, shall knowingly visit any dive or resort of the character referred to above. Article 192. Importation and sale of prohibited drugs. The penalty of prisión correccional in its medium and maximum periods, and a fine ranging from 300 to 10,000 pesos shall be imposed upon any person who shall import or bring into the Philippine Islands any prohibited drug. The same penalty shall be imposed upon any person who shall unlawfully sell or deliver to another prohibited drug. Article 193. Illegal possession of opium pipe or other paraphernalia for the use of any prohibited drug. The penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon any person who, not being authorized by law, shall possess any opium pipe or other paraphernalia for smoking, injecting, administering or using opium or any prohibited drug. The illegal possession of an opium pipe or other paraphernalia for using any other prohibited drug shall be prima facie evidence that its possessor has used said drug. Article 194. Prescribing opium unnecessary for a patient. The penalty of prisión correccional or a fine ranging from 300 to 10,000 pesos, or both shall be imposed upon any physician or dentist who shall prescribe opium for any person whose physical condition does not require the use of the same. Title 6. Crimes against Public Morals. Chapter 1. Gambling and Betting. Article 195. What acts are punishable in gambling? The penalty of arresto mayor or a fine not exceeding 200 pesos, and, in case of recidivism, the penalty of arresto mayor or a fine ranging from 200 or 6,000 pesos shall be imposed upon 1. Any person other than those referred to in subsections and who, in any manner shall directly or indirectly take part in any game of monte, judang or any other form of lottery, policy, banking, or percentage game, dog races, or any other game of scheme the result of which depends wholly or chiefly upon chance or hazard, or wherein wagers consisting of money, articles of value or representative of value are made, or in the exploitation or use of any other mechanical invention or contrivance to determine by chance the loser or winner of money or any object or representative of value. 2. Any person who shall knowingly permit any form of gambling referred to in the preceding subdivision to be carried on in any uninhabited or uninhabited place of any building, vessel or other means of transportation owned or controlled by him. If the place where gambling is carried on has the reputation of a gambling place, or that prohibited gambling is frequently carried on therein, the culprit shall be punished by the penalty provided for in this article in its maximum period. The penalty of prison correctional in its maximum degree shall be imposed upon the maintainer, conductor, or banker in a game of judang or any similar game. The penalty of prison correctional in its medium degree shall be imposed upon any person who shall, knowingly and without lawful purpose, have in his possession in lottery list, paper or other matter containing letters, figures, signs or symbols which pertain to or are in any manner used in the game of judang or any similar game which has taken place or about to take place. Article 196. Importation, sale and possession of lottery tickets or advertisements. The penalty of arresto mayor in its maximum period to prison correctional in its minimum period or a fine ranging from 200 to 2,000 pesos, or both, in the discretion of the court, shall be imposed upon any person who shall import into the Philippine Islands from any foreign place, or port any lottery ticket or advertisement or, in connivance with the importer, shall sell or distribute the same. Any person who shall knowingly and with intent to use them, have in his possession lottery tickets or advertisements, or shall sell or distribute the same without connivance with the importer of the same, shall be punished by arresto mayor, or a fine not exceeding 200 pesos, or both, in the discretion of the court. The possession of any lottery ticket or advertisement shall be prima facie evidence of an intent to sell, distribute or use the same in the Philippine Islands. Article 197. Betting in sports contests. The penalty of arresto mayor or a fine not exceeding 200 pesos, or both, shall be imposed upon any person who shall bet money or any object or article of value or representative of value upon the result of any boxing or other sports contests. Article 198. Illegal betting on horse race. The penalty of arresto mayor or a fine not exceeding 200 pesos, or both, shall be imposed upon any person who except during the period allowed by law, shall be on horse races. The penalty of arresto mayor or a fine ranging from 200 to 2,000 pesos, or both, shall be imposed upon any person who, under the same circumstances, shall maintain or employ a totalizer or other device or scheme for betting on horse races or realizing any profit therefrom. For the purposes of this article, any race held in the same day at the same place shall be held punishable as a separate offense, and if the same be committed by any partnership, corporation or association, the president and the directors or managers thereof shall be deemed to be principals in the offense if they have consented to or knowingly tolerated its commission. Article 199. Illegal cockfighting. The penalty of arresto mayor or a fine not exceeding 200 pesos, or both, in the discretion of the court, shall be imposed upon 1. Any person who directly or indirectly participates in cockfights, by betting money or other valuable things, or who organizes cockfights at which bets are made, on a day other than those permitted by law. 2. Any person who directly or indirectly participates in cockfights, at a place other than a licensed cockpit. Chapter 2. Offenses against decency and good customs. Article 200. Grave scandal. The penalties of arresto mayor and public censure shall be imposed upon any person who shall offend against decency or good customs by any highly scandalous conduct not expressly falling within any other article of this code. Article 201. Immoral doctrines, obscene publications and exhibitions and indecent shows. The penalty of prison mayor or a fine ranging from 6,000 to 12,000 pesos, or both such imprisonment and fine, shall be imposed upon those who shall publicly expound or proclaim doctrines openly contrary to public morals. The authors of obscene literature, published with their knowledge in any form, the editors publishing such literature, and the owners-operators of the establishment selling the same. Those who, in theaters, fairs, cinematographs or any other place, exhibit indecent or immoral plays, scenes, acts or shows, whether live or in film, which are prescribed by virtue hereof, shall include those which glorify criminals or condone crimes, serve no other purpose but to satisfy the market for violence, lust or pornography, offend any race or religion, tend to abet traffic in and use of prohibited drugs, and are contrary to law, public order, morals, and good customs, established policies, lawful orders, decrees and edicts. Those who shall sell, give away or exhibit films, prints, engravings, sculpture or literature which are offensive to morals. Article 202. Vagrants and prostitutes. Penalty. The following are vagrants. 1. Any person having no apparent means of subsistence, who has the physical ability to work and who neglects to apply himself or herself to some lawful calling. 2. Any person found loitering about public or semi-public buildings or places, or trampling or wandering about the country or the streets without visible means of support. 3. Any idle or dissolute person who lodges in houses of ill fame, ruffians or pimps and those who habitually associate with prostitutes. 4. Any person who, not being included in the provisions of other articles of this code, shall be found loitering in any inhabited or uninhabited place belonging to another without any lawful or justifiable purpose. 5. Prostitutes. For the purposes of this article, women who, for money or profit, habitually indulge in sexual intercourse or lascivious conduct, are deemed to be prostitutes. Any person found guilty of any of the offenses covered by this article shall be punished by arresto menor or a fine not exceeding 200 pesos, and in case of recidivism, by arresto mayor in its medium period de prisión correccional in its minimum period, or a fine ranging from 200 to 2,000 pesos, or both, in the discretion of the court.